to the Bills Committee meeting of the Merchant Shipping Safe and Environmentally Sound Recycling of Ships Bill. This is the first meeting. We have a quorum, and this is the appointed time. Let me ask the administration to come in.
Yuen-man 我知道，佢改到嚇，由史強先生講嚇。好，我哋歡迎呢。
Let's welcome Ms. Yuen-man, Deputy Secretary for Transport and Logistics, Mr. Shu Tiang, Deputy Director of Marine, Mr. Klaus, Principal Assistant Secretary for Transport and Logistics, and others. Altogether, 6 members for joining our meeting. Would you like to give a start now, Deputy Secretary? Thank you, Chair. This is the Merchant Shipping Safe and Environmentally Sound Recycling of Ships Bill, hereinafter called Bill. It seeks to implement the Hong Kong Convention. The Hong Kong International Convention for the Safe and Environmentally Sound Recycling of Ships, or Hong Kong Convention 2009, was adopted in Hong Kong at the Diplomatic Conference of the International Maritime Organization held in Hong Kong between the 11th of May of 2009. It aims to ensure that ship recycling does not pose any unnecessary risk to human health, safety, or the environmental by addressing various issues in relation to ship recycling. The Hong Kong Convention stipulates that the convention will only enter into force 24 months after certain conditions, including but not limited to having not less than 15 contracting states are met. Now, the requirement was met in the middle of 2023, and we have since then been proceeding with preparing for enactment. Although we share the same objective, some of the provisions are not fully covered in the local legislation. There is a need, therefore, to enact a new piece of local legislation and subsidiary legislation for the implementation of the Hong Kong Convention. We plan to pass the bill before the global entry into force date on the 26th of June 2025, and subject to the CPG's ratification, this will apply to Hong Kong, and then we will give effect to this bill. The bill and the subsidiary legislation to be made seek to regulate ship recycling activities in Hong Kong. It also regulates the work environment and the materials, etc. Due to high land costs and labor costs and low demand for recycled materials, ship recycling facilities have been phased out in Hong Kong, and there is a minimal chance that SRFs or ship recycling facilities will emerge in Hong Kong in the future. However, Hong Kong is the 4th largest shipping register in the world with more than 2,300 ships at sail. It is important that we ensure their compliance of applicable Hong Kong registered ships with Hong Kong Convention regardless of their locations, so as to minimize the risk associated with ship recycling activities. Now, the bill contains empowering provisions, and all the implementation details will be set out in the subsidiary legislation. The Marine Department will elaborate on details of the bill. I urge members to support passage of the bill so that in terms of ship recycling and the latest requirements, we can bring our standards on the par with the international standards. I will now give the floor to my colleague, Mr. Shu Tiang, from the Marine Department to give you more details about the bill. Thank you. All right, Mr. Shi, thank you. Good afternoon, Chairman, members. I will go through the bill with members now. The Hong Kong International Convention for the Safe and Environmentally Sound Recycling of Ships 2009, or Hong Kong Convention, was adopted in Hong Kong, China at the Diplomatic Conference of the IMO held in Hong Kong in 2009. It's also called the Hong Kong Convention as a result. Well, this convention was drawn up in collaboration with other international organizations, such as the ILO. It aims to ensure that ship recycling does not pose unnecessary risk to human health, safety, or the environment. There are 24 contracting states under the Hong Kong Convention, including the 3 major shipping registers, Panama and Marshall Islands, as well as Liberia. There are also major ship surveying countries such as Bangladesh, India, Pakistan, etc. Now, the picture shows you the condition of ship recycling facilities in Hong Kong at the moment. Now, there are some requirements. The first type relates to ships. I'll go through them very briefly. Let me just say that this bill will not spell out very detailed requirements of the convention because these details will be provided in the regulations. Now, first of all, in terms of materials, ship owners are required to compile an inventory of hazardous materials, which record the quantity and location of hazardous materials. The Marine Department will then proceed to inspecting the vessel, and following successful inspection or surveying, an international certificate on inventory of hazardous materials will be issued. It will be renewed every 5 years to ensure that the list continues to reflect correctly the hazardous materials on the ship. The certificate will be issued by the Marine Department or recognized organizations. And then 3 months before the commencement of recycling of a ship, an International Ready for Recycling Certificate or IRRC will be issued by the Marine Department or recognized organizations to confirm the validity of the inventory and suitability of the selected ship recycling facility. On ship recycling facilities or SRFs, the competent authority will need to ensure that certificates are issued by a competent or recognized organization. Now, this is called the Document of Authorization to Conduct Ship Recycling, DASR. It sets out the size or type of ship and quantities of materials or hazardous materials, etc. It is to be renewed every 5 years, and it is to be issued by the Marine Department or recognized organizations. There is also a need to verify the IHM, and as such, a ship recycling plan will have to be drawn up in relation to each and every vessel. And this plan is also to be approved by the competent authority of the recycling state. There are obligations of parties to the Hong Kong Convention. For example, the contracting parties will need to conduct investigation into or report ships or ship recycling facilities in violation of the Hong Kong Convention. The Hong Kong SAR government will also need to conduct surveys and issue certificates to Hong Kong flagged ships to ensure compliance with Hong Kong Convention with appropriate sanctions. And the relevant information should also be given to the IMO in the reporting process. Due to high labor and land costs in Hong Kong, with low demand for recycled materials in Hong Kong, since the 1970s, ship recycling facilities or SRFs have progressively been phased out. At the moment, there are no SRFs in Hong Kong, and it is rather unlikely to have SRFs that need to comply with the Hong Kong Convention in Hong Kong in the future. However, Hong Kong Convention applies to the facilities and ships, and taking into account that we have more than 2,300 Hong Kong flagged ships plying around the world, we must ensure compliance of applicable Hong Kong registered ships with the convention regardless of their locations. Coming back to the bill, the main purpose of the bill is to implement the Hong Kong Convention. Apart from the Hong Kong Convention, however, there may be other international conventions or requirements relating to the ship recycling facilities. And with passage of the bill, there is no need to enact a new piece of legislation to incorporate other international conventions. We've also taken into account the fact that the Hong Kong Convention or any other international conventions relevant to the issue may be amended or updated, or new requirements may be imposed. To reduce the frequency of legislative amendments, we propose to adopt a direct reference approach in the new legislation. The bill mainly provides for key empowering provisions. The requirements and implementation details will not be provided in the bill, but rather in the subsidiary legislation to be enacted at a later stage.
We have already started drafting the relevant subsidiary legislation. Let me now talk about the 18 clauses of the bill. The bill is divided into 5 parts, contains 18 clauses. Part 1, preliminary. Part 2, power of the Secretary for Transport and Logistics to make regulations to implement the convention. That would also empower the Director of Marine as well as the administration and competent authorities' powers. There are also powers to inspect the relevant premises and take enforcement action. If any deficiency is identified, the director may issue directions to rectify the relevant deficiency. Part 4 is about exemption power of the Director of Marine. Part 5 is some miscellaneous provisions. For example, the power of the public to inspect the convention. The bill also provides for some empowering provisions for the Secretary for Transport and Logistics to make regulations in order to provide for the safe and environmentally sound recycling of ships, give effect to the Hong Kong Convention, as well as requiring compliance with any international agreement or any of its reference international instruments that relate to the safe and environmentally sound recycling of ships. The regulations made by the Secretary for Transport and Logistics could empower the Director of Marine to exercise a number of powers, including exercise power that the Hong Kong Convention conferred to a competent authority and an administration. This will be the Director of Marine's power in future. The Director of Marine is also empowered to require an owner or an operator to rectify the deficiency, and the relevant ships cannot be recycled or set sail without the permission of the Director of Marine before rectification. And again, the Director may grant exemptions if necessary. The legislative proposals also include the authorization and cancellation of the authorization of SRFs referred to in Clause 13.1 and Clause 14.1. When a deficiency is identified, the Director would issue some directions, and the directions would have to be complied with. There's also the issuance of a specified document in electronic form. the power to create offenses, charge fees, and appeal against the director's decision. The bill empowers authorized officers to implement the requirements under the Hong Kong Convention by boarding ships and entering premises. And there are different scenarios, for example, when there's an emergency or when there isn't an emergency. Basically, the authorized officers may apply for a magistrate's warrant to enter the relevant premises or board the ships. That's it from me. I'll probably let another colleague of mine to lead the clause-by-clause examination. All right. Actually, before that, we will discuss the policy-related issues. Members who would like to speak, please press the request to speak button. Right. I can see that 4 members want to speak. I'll read out the order in which members are going to speak. Dr. Johnny, Mr. Stephen Ho, Mr. Chan Siu-hong, and myself. I'll assign a 5-minute time limit. Questions and answers included. Dr. Johnny, please. Thank you, Chair. The administration talked about the background for the proposals, the legislative intent, and the specific proposals. I want to ask some questions. We may not have ship recycling companies anymore, but we are still the 4th largest place for shipping registration. We have more than 2,300 ships that have registered with us. Our ships are operating around the world. We need to ensure Hong Kong ships, no matter where they are, would comply with the relevant provisions in the convention. Has the government gauged how many ships may need rectification, thus costing the industry? Do we have adequate personnel, and whether the relevant personnel have the requisite experience to implement the Hong Kong Convention? If not, do we need to provide more training or do something else about that? Thank you. Amy? Undersecretary. Deputy Secretary. Thank you. Every year, if some certificates have to be issued, the Marine Department would have some recognized organizations. Generally, they are the classification societies to issue the relevant certificates. And for this bill in particular, these certificates are more likely than not issued by these recognized organizations. So we do not expect a significant increase in costs. In general, these certificates will be issued in packages, so there may be multiple certificates issued at the same time. For the 2,300 ships registered in Hong Kong, these are mostly merchant ships, and I think all along Hong Kong ships are of very high quality, and shipping registration in Hong Kong is known for being safe and being quite secure. We actually have a very low port state detention rate. In 2024, we only have a 0.69%. So every 1,000 ships, we only have 6.9 ships detained. In the world, the rest of the world, it is 3.3%. So every 1,000 ships, there would be 33 ships that are detained. We have a very low rate, as said. Thank you. Any follow-up questions? Oh, Mr. Chan Siu-hong. Oh, is it not you? Mr. Stephen Ho, excuse me. Thank you. I also have a question on costs, but Dr. Johnny already asked that. I want to focus on future costs then, on ship recycling. We will have some new provisions, you may trust the classification societies. But I think you should liaise with the classification societies to see what the approximate costs are. If they are much higher than what was said during consultation, will the government take any action? We do not have many ship recycling facilities in Hong Kong. I think we need some facilities in order to meet the international requirements. Or at least we need to identify where these facilities are. We need to make sure the facilities are up to par to provide the relevant services. If there are no facilities that can actually provide services to the relevant standards, it may be difficult for Hong Kong ships to comply with the requirements. So I think we need to make sure, for costs at least, we need to make sure there is adequate market supply. Otherwise, it will increase eventually the costs of ship recycling. We have talked about how Hong Kong ships are of very high quality. We have only 6 out of 1,000 ships being detained. I'm not sure why the 6 ships are detained, though. Have you gauged why the 6 ships were detained? Is it something to do with the personnel? Is it something to do with the company? What happened? That's my question. Thank you. Deputy Secretary. Thank you. The Marine Department and the Shipping Registry enhanced communication in recent years with ship owners. And Mr. Ho said specifically we should liaise on costs with classification societies. We'll definitely do that because we want to provide high quality services to ship owners, and we think they should know about what the approximate costs are. We have 24 countries that have signed the convention, and for shipping recycling facilities, they do not serve only ships of a particular place. They serve ships from different parts of the world. And we have the states that house these major ship recycling facilities sign this convention. We believe there should be adequate supply of the services. Excuse me, Chair, can I follow up on this? For the 2,300 ships, do they currently go to these ship recycling facilities? All of them. We do not have the relevant information because some ships have a lifespan of 20 to 30 years. We will only know when ships reach the end of their lifespan and are being recycled. So as I said, if ships are to be recycled and the ship owners want to buy, say, new energy ships, then they will have some ship recycling to be done. And with the 26th of June being the Hong Kong Convention coming into effect, we believe we'll know clearer what is going to happen. Let me follow up on this. We have a number of countries that have signed the convention, but I think we should already have information on what happened in the past, how ships and where ships were recycled. Say if they go to Macau, then it would not be as you thought, right? So companies may have to switch to other places. I just want to have the relevant information. Can you provide the relevant information to us? Definitely. We will convey the relevant information to you once we have obtained the relevant information. We'll also convey the information to the ship owners. Thank you. Next, Mr. Chan Siu-hong. Thank you, Chair. We talked about this at the panel on economic development meeting in December last year, and the proposals received general support from members, we have to implement the Hong Kong Convention because Hong Kong is an international shipping center. We need to meet the standards, especially for certain operations. In last year's discussions, there was general support from members, and now we have the finalized proposals. I can't wait to get into clause by clause examination, and I can't wait for the eventual passage of the bill. I also have some questions. I would like to seek clarification from the Deputy Secretary to dispel some public misconceptions. It is said that the convention will come into effect on 26th of June. It is not far from now. I believe the bill should be passed before then, but in the unfortunate event that the bill cannot be passed by June 26th, according to my understanding, and as said on the last occasion at the panel on economic development meeting, before the central authorities' approval for the implementation of the convention in Hong Kong, we are not breaching our duties, right? But of course, the Central People's Government would have to wait until the bill is passed locally, then they would say that the convention should be made applicable to Hong Kong. So I want to ask the Deputy Secretary, when will the bill be enacted exactly? I believe that there will be details to be promulgated in legislation. There will only be the legislative framework, and we have talked as early as 2009 implementing the convention. Finally, in 2023, we have the conditions of the convention met. I believe you have already made the relevant preparations because you were already talking about the proposals in December last year. When will you actually be able to implement this? We have some details that have not been fleshed out. If you don't talk about the details now, it may not help with the industry in their compliance. Can you talk more about that?
My second question is to pick up on what Mr. Ho said. Let's see if I've got it right. The Hong Kong Convention will enter into force and be applied to Hong Kong. And that's the background of this relevant bill, Merchant Shipping Safe and Environmentally Sound Recycling of Ships. The bill regulates 2,300 Hong Kong registered ships, regardless of their locations. They will be bound by the Hong Kong Convention as well as this piece of legislation. So, like the Deputy Secretary just now said, if a Hong Kong registered ship then sails to one of the 24 contracting states for ship recycling activities, then they must of course observe this piece of legislation, or else the registration may be revoked. Now, what if this ship goes elsewhere other than the contracting states where SRFs are also available? Although I believe that after this bill comes into force, the chance may be minimal. I just want to know what happens if the ship decides to sail to one of the non-contracting parties for the SRF purpose. Yes, let me take the question on global entry into force date. In 2023, we learned that the prerequisites were met and that the Hong Kong Convention could come into force. Well, we've been liaising closely with the Central People's Government for early rectification of the Hong Kong Convention. At the same time, we were also proceeding to formulation of the bill, and that is why we're here to discuss the bill now. And we are taking a parallel approach. With members' support, I hope that the regulation can be tabled into Council for approval by negative vetting before summer recess. Well, that is our target as we await for direction from the Central People's Government. And meanwhile, we want to complete all the legislative steps as quickly as possible. Sorry, a point of clarification, Chairman. As I understand, the regulation will contain implementation details. These details will have binding effect. In fact, you have the draft ready, haven't you? You're just waiting for passage of the bill, and then by negative vetting, you can also float the regulation for approval by Legislative. Is that the case? Or are there hiccups in ironing out the details with the sector? No, we're just in the process of drawing up the regulation. We need to do things step by step. We're now proceeding with the bill, and once the bill has been passed, we'll proceed to making regulations. Our goal is to float the regulation before summer recess, on the premise that this bill is passed. However, even with passage of the bill, the convention does not come into force in Hong Kong because we need to publish a notice in the Gazette. And when everything's ready, we still need to wait for direction from the Central People's Government. And once we have that as well, we will proceed to making a notice for it to be published in the Gazette. You asked about the deadline, the 26th of June. And in fact, even if this doesn't come to fruition before the set date, we still have a grace period allowed. I will let my colleague explain further. That is how they will approach the matter before the Hong Kong Convention is ratified and applied in Hong Kong. Right, if the Hong Kong Convention comes into force globally on the 26th of June, but not for Hong Kong since no ratification has been made yet, then we're still required to observe the requirements as we're one of the party states. But technically we're not able to issue certificates. We will need to ask, say, a classification society to issue certificates on our behalf. Well, it will follow the same template as the one set out in the Hong Kong Convention, only that the Marine Department cannot issue this certificate as a contracting party. Now, say for ship recycling, if the ship is dismantled at the SRF in one of the 24 contracting states, a certificate is still required to meet the convention's requirement. DS, may I confirm that this will only arise after the CPG rectifies the HKC, is that right? The answer is in the affirmative. Yes, we need to wait for CPG to rectify the HKC and for it to apply to Hong Kong first. Second question. Just to confirm, say if a Hong Kong registered ship goes to another place, including one of the 24 contracting states for ship recycling, then like the DS and the Marine Department said, this ship must observe all requirements under the convention before proceeding to ship recycling. Otherwise, coming back to Hong Kong, this ship will not be allowed to retain the registration by, say, the classification society. The mic is not switched on. Well, it's not officially a party to the convention, but we will inform the classification society that the technical requirements are not met, and as such, the certificate cannot be issued. Any follow-up? What about other ships sailing to Hong Kong? If the ship fails to observe the relevant requirements in Hong Kong, including, for example, the preparation of this inventory of hazardous materials, then what is the intent of the bill? Is it that they are not allowed to carry out ship recycling in Hong Kong? Are there any ways to ensure compliance? Let's say if a ship breaches certain requirements under the Merchant Shipping Safe and Environmentally Sound Recycling of Ships Ordinance, then how should it be dealt with? Yes, if it is a non-Hong Kong registered ship that sails to Hong Kong, there are still certification requirements to be followed according to the country of the vessel, and if SR ship recycling takes place in Hong Kong, and if the ship is in our waters, they need to observe the convention's requirement. Now, let's say if it's a Hong Kong registered ship that travels around the world, then the inventory of hazardous materials will need to follow the requirements of the Hong Kong Convention. We do not have ship recycling facilities or activities in Hong Kong at the moment. Next, my turn. I have 4 questions. This ship does not apply to warships or non-commercial vessels subject to the exception. Let's say if it's a non-commercial ship that must be scrapped, what should be done? Should we follow the Marine Department's requirements, and what about the environmental requirements? There is nothing to regulate the ships I mentioned, such as the ones solely used for government non-commercial service. The second question is this: is that for Article 4, Chapter 3 of the Convention, there is this non-preferential treatment principle, and that is no preferential treatment should be given to ships, the countries of which have not ratified the Convention. And a more stringent requirement should be imposed on these ships, the countries of which have not ratified the Convention. Now, the details at the moment have not been included in the bill, is that right? The third question is this: for Hong Kong registered ships, should there be a violation? Which which should be the authority of oversight? Last question. An appeal mechanism. In Clause 13.1, the director may give directions to the master or owner of the ship requiring that the ship stay put before the deficiency is rectified. In Clause 14.1, the director may also give directions to the owner or operator of the ship recycling facility and require them not to proceed to scrapping of the ship before the deficiency is rectified. That means the director is empowered to impose restrictions on the sailing of ships, and stakeholders are rather concerned. Well, according to the stakeholders, they would like to have a review mechanism. Will the Marine Department consider this suggestion? In order for requirements to be met, will an appeal panel or committee be set up for this purpose? Well, this is at the moment not included in the bill. These are the 4 questions I'd like to ask. So, DS, over to you. First question: this bill does not apply to warships, for example, and what happens if the scrapping activity takes place in Hong Kong? The fact is we do not have a ship recycling facility in Hong Kong at the moment, so no ship scrapping will take place here, and that is not really a major concern. If by then a ship recycling facility emerges, we will gauge the situation again. Chairman, you also mentioned clauses 13.1, 14.1, and stakeholders' request for a review mechanism. Now, currently, in the event of a deficiency, the director may issue a notice or give direction for rectification to take place to rectify the deficiency. Otherwise, no scrapping may be allowed and no sailing may be allowed. Now, this is a well-established mechanism for Hong Kong registered ships. If they want to continue with their business, they must rectify the deficiency as quickly as possible. Usually, the directions or notices will not be issued willy-nilly. We usually tell the persons in charge on the spot before formally issuing the notice. Now, if the owner or the master is ignorant about the rectification, then they can approach the relevant organizations such as a classification society on how they should rectify this deficiency. We'll also keep in view the latest development, and based on the operational needs, we may consider setting up an appeal mechanism. About the preferential treatment you mentioned in the convention, I will give the floor to the Director of Marine. Well, this is a provision commonly found in international conventions. That applies not only to Hong Kong registered ships but non-Hong Kong registered ships coming to Hong Kong. They are required to meet the Hong Kong Convention's requirements. So even before Hong Kong joins the convention as a contracting party, a certificate from the classification society is required. So likewise, we need the ships coming to Hong Kong to meet the requirements in terms of ship recycling facilities. Right, so this is already happening. Yes, it is applicable to non-Hong Kong registered ships sailing to Hong Kong.
What about non-Hong Kong registered ships? We also have the power to inspect vessels regardless of whether they are Hong Kong registered ships or non-Hong Kong registered ships. If they have breached the relevant convention or laws, we can still initiate prosecutions. Well, for other ships, what will happen for what happened out in other jurisdictions? Well, it would be the Marine Department. Oh, so you would deal with that too. We will liaise with the relevant port authorities and collect evidence. Thank you. All right, if there are no other questions from members, we'll go into clause-by-clause examination. Members, the legal advisor issued a letter to the administration to raise some questions. The paper number is LC paper number CB brackets 3478/2025 brackets 01. We also have a reply from the administration to the letter. LC paper number CB brackets 3503/2025 brackets 01. These are included in the agenda. Legal advisor, during the clause-by-clause examination, please remind members of any legal and drafting issues. If necessary, I will invite the administration to give explanations. We can first scrutinize the Chinese text. Please refer to the blue bills, LC paper number CB brackets 2515/2025. Administration, please lead the clause-by-clause examination. Thank you. Chair. Yes, Mr. Ching. Or Mr. Chan. Klaus Chan. Thank you. The bill's long title is that it is a bill to provide for the safe and environmentally sound recycling of ships and to provide for related matters, that is to implement the Hong Kong Convention. Thank you. Any questions from members? No, please proceed. We have 18 clauses in 5 parts. Part 1, preliminary. Clause 1, short title and commencement. It sets out the short title as well as the ordinance is to come into operation on a day to be appointed by the Secretary for Transport and Logistics by notice published in the Gazette. Any questions from members? If not, please proceed. Thank you. Clause 2, interpretation. This includes the definitions needed in the bill. Most of them are found in the convention, or there are definitions adopted in other marine legislation. I have a question on this. Should there be amendments in future to the provisions in this bill? Are we to go with the updated version? I assume that is the case. If that is the case, should we make sure there are provisions that would say specifically we will not compromise national security interests? We do not have such content in the convention, but I think with updates to the convention, should we make sure the updates would operate on the premise of Hong Kong's national security not being compromised? Thank you, Deputy Secretary. Thank you. We are adopting a direct reference approach. What is said in the convention, no matter what the version is, we will refer to the latest version that applies to Hong Kong. Well, actually, in the national security law, we do have some blanket clauses. That is, all applicable Hong Kong laws must conform to the relevant legislation. There's no need to provide for national security related provisions in each and every legislation. All right? Thank you. Please proceed. Thank you. Clause 3 is application. What the ordinance applies to specifically. For Hong Kong ships, if they are engaged or have been engaged in international voyages and it is a ship of not less than 500 gross tonnage, wherever the ship is, they will be regulated by the ordinance. For non-Hong Kong ships, if they have been engaged in international voyages or are engaged in international voyages, if it is a ship of not less than 500 gross tonnage, if it is in the waters of Hong Kong, they will be regulated. For a ship owned or operated by the government that is used on any service, excluding one that is used only on government non-commercial service, they are also applicable. But this ordinance does not apply to those categories in 2A to D, but we will make sure the operations of these types of vessels will as much as possible conform to the provisions articles of the convention. In fact, in Article 3.3, it requires the relevant convention states to, as much as possible, implement the Hong Kong Convention by adopting appropriate measures. Thank you. I actually have a question on a term in interpretation on the definition of domestic premises. For domestic premises, if it does not say in the title it is domestic premises, but someone lives in the premises, do you see it as domestic premises or non-domestic premises? Say for a ship recycling facility, it may house some ship recycling workers' accommodation. What would you see that as? Thank you, Deputy Secretary. I think from the land leases, we should be able to tell whether they are domestic premises. For some industrial and commercial buildings, they are not meant for residential purposes. Even if there are some people living there, it does not change the nature of the premises. All right, so you'll go with the land leases, right? Right. Mr. Chan Siu-hong. Thank you, Chair. I have a suggestion. Representatives of the administration said a lot of things earlier. I think for the benefit of examining each and every part of the bill, I would like to ask the administration to say specifically what section they're talking about. And honestly, I think we skip too much. We skip straight to subsections 1 and 2 of section 3. It is a little too quick. We were not able to ask them questions before. So please, can we just go through each and every part? If there are no particular questions on a subsection, I think we can skip that then. All right. Where are we now exactly, Chair? I think we are asking about domestic premises. Can we go through that by starting with, say, convention country and then hazardous material? All right, can you start from clause 2 again? I see Mr. Frankie Yik also has some questions. I want to ask about clause 3, but maybe we can go through clause 2 first. All right? I also have a question on international voyage. It says it means a voyage between Hong Kong and a port outside the People's Republic of China. It essentially makes Hong Kong and the PRC on the same level. I mean, in English, it's fine because it says specifically a port outside the People's Republic of China, but then in Chinese, it does not spell that out. So, should we change the wording in Chinese to emphasize the fact that it's just a port? Because I think it can be confusing. It basically elevates Hong Kong to the status of the country. Thank you. Deputy Secretary. Thank you. Well, actually, it is the case that Hong Kong is seen as only a place in Chinese. It actually has the same meaning as the English text. If we add something else in Chinese, it may not be the case that we would continue to have an equivalent translation. I think adding a part to this would actually clarify things. Yes, Mr. Ching or Mr. Chan. Excuse me. Well, we're talking about in the text still a port outside the PRC, not about just the PRC. So we have not elevated the status of Hong Kong to the level of the country with this drafting. Thank you. Any other questions from members? If not, please proceed. We were at, excuse me, I have another question on the term operator. When you're talking about the owner of the facility, would that mean only the individual, or would it already cover, say, the company concerned? Thank you. Chair, for the operator, it says in particular in relation to a ship recycling facility. And after that, it says the owner of the facility. So it would mean for the facility itself. It would mean the owner of the facility is covered under the definition of operator. Okay, understood. Oh, can we start from clause 3 now? Yes, Mr. Chen Siu-hong, you would like to speak. Excuse me, for C2146 in Chinese, we have some definitions for Hong Kong ships and ships. And I'm sure Mr. Frankie Yik would remember we talked about the definition of ships for the scrutiny of another bill. We have not only Hong Kong ships that are to be regulated, but also non-Hong Kong ships that are in the waters of Hong Kong. In the interpretation, I have actually referred to Chapter 548, Merchant Shipping, Local Shipping Ordinance, Local Vessels Ordinance. It would cover multiple types of vessels, like waterplanes and other types of vessels. They are all counted as ships. In regulation, you have an additional threshold, being that it should be above 500 gross tonnage. But I'm confused. Why are there different definitions of ships here?
Yes, thank you, Mr. Chan, for his question. The definition of the term ship in this bill is drawn up on the basis of the definition of the Hong Kong Convention, Article 2. For ships applicable to, say, the ship recycling activities set out in the convention, the definition may be different from the definition provided in the local definition. So the best option is to follow the Hong Kong Convention's definition of ship. Chairman, if this comes into force without adding say, junk boat to the definition of ship as a without adding definition, then let's say if it's above 500 gross tonnage, then does it mean that it's not captured by this bill? If it's scrapped in Hong Kong waters or elsewhere, then it's not covered. Is that right? Yes. Well, the crux of the matter is whether it has an international voyage, whether it has a gross tonnage of over 500, and whether it travels outside the port of Hong Kong and the PRC. Right. Of course, when it comes to law drafting, we need to be precise and succinct at the same time. The bill should not be protracted. We need to be effective. But still, some circumstances may arise in the future. We need to make sure that this is in line with your legislative intent. Don't just tell me that you have mirrored the definition on the basis of the conventions, because I just mentioned some scenarios happening in the Hong Kong waters, including the involvement of a non-Hong Kong registered ship. Let's say if we have a junk boat, dynamically supported craft, seaplane, etc., plying Hong Kong waters, because last time we also discussed this relevant legislation on alcohol consumption and marine safety. There may be some technologies emerging unknown to us. That means if this is a dynamically supported craft, applying in Hong Kong waters, taking an international voyage, then there is no need to follow the local legislation nor the Hong Kong Convention, right? Yes. Thank you. B2 already captures this kind of vessels you mentioned. A floating craft includes junk boats, etc. So for a Chinese-style junk or other forms of sailboats, yachts, etc., I think that this will be captured by the term floating craft. Right, Chairman, I suggest that DS to keep her mind open. You don't need to tell me a yes or no answer now. Just go back and imagine this scenario. You can take this approach. You can mirror the definition and copy straight from the Hong Kong Convention's definition. Perhaps you will tell me that as we have not any SRF in Hong Kong, we don't need to be too concerned about this. Or you can take the other approach, go back and add a little bit to this definition. Because last time we checked this legislation, any other description of vessels in Hong Kong in the waters of Hong Kong. But then you've just reassured us that in fact under B3 it captures other forms of smaller crafts or boats. Mr. Lok from the Department of Justice, any observation? Thank you, Chairman. The Deputy Secretary already gave a very detailed answer, but I'd like to supplement further. If we take a look at the definition point A, it means a vessel of any type operating or having operated in a marine environment. So that's really almost a catch-all provision. Any kind of boats, yachts, vessels you can think of are already captured in point A. DS, please note Mr. Chan's suggestion and mull it over. Mr. Frankie Yik. Thank you, Chair. My question is on Clause 1C. Will the government tell me what kind of ship is owned or operated by the government that is used on any service excluding one that is used only on government non-commercial service? So what kind of government ship offers commercial service? Why is there a need to have this subclause? Thank you for your comment. This is actually in line with the convention's requirement. It does not include government ship providing commercial service, so we need to spell it out clearly. In fact, this does not apply to Hong Kong. We do not have that kind of ship, but it does exist elsewhere. Following up on my member's question, I want to know whether the definition relates to international voyage. This bill regulates ships taking international voyage. For no purpose at all, I may wish to set sail some large junk or yacht with gross tonnage of about 500, and I should not be captured by the bill, right? Say if you travel to a port outside of Hong Kong or the PRC with a yacht, which is a luxury yacht with sufficient horsepower to go to the Philippines, then that would be all right. I also have a question on C2148 about the application clause in English. It says the government and the government. The government refers to Hong Kong SAR government, right? Whereas a government refers to the government of any place. Chairman, thank you for your question. 31C refers to the Hong Kong SAR government. 32D refers to a government, the government of another place. And also 31C refers to government service. So the service provided by the Hong Kong SAR government. 31C, yes, it refers to the services provided by the Hong Kong SAR government. Right, so for 3.2, it refers to the government of any other place, and government non-commercial service likewise. What about 3.1? Isn't it clearer to include Hong Kong SAR before government? Yes, if we take a look at the English version, it's government non-commercial service, and government refers to the types of service. Noted. So, I think that there is some ambiguity here. Let's ask Mr. Look from DOJ. 3.1C in bracket, government non-commercial service. This is exactly the wording used in the convention. In order to fully reflect what the convention entails, we have copied exactly the same wording from the convention. But 3.1C, as you see, you have government with capital letter G and without. I think that accounts for the difference. If it's in capital letter, then it is the Hong Kong SAR government. Thank you, Chairman. I need to explain in greater detail. For government non-commercial service, the term actually comes from the convention, then that's the government without the capital G. Since we're taking the direct reference approach, we have copied the term and put it in the context of a Hong Kong SAR government. If these are read together, it means government non-commercial service of the Hong Kong SAR government. That's how it should be read. Any other questions? Mr. Chan Siu Hong. Thank you, Chair. I have a question about bracket 1, bracket 2 of clause 3. You mentioned non-government government non-commercial service. I'd like to put this question to the DS or the Marine Department. Why is there a particular reference to non-commercial service? Is that commercial service of the government? The next question is this. At this moment, the Hong Kong SAR government does not provide government commercial service. But what happens if there is a change? Do we need to amend this provision? As mentioned by Mr. Loke, we respect the convention, and this is why the term has been copied onto the bill. It says here that the ship owned or operated by the government should observe the legal requirements. So in the future, if the Hong Kong SAR government operates a ship that provides commercial service, then it must observe the requirement. But we don't envisage the Hong Kong SAR government providing any commercial service, so members should be reassured. The way it is drafted at the moment is such that it does not specifically refer to the SAR government. So even if the Hong Kong SAR government owns a ship that provides commercial service, there is no need to observe 3.1C, right? No. 3.1C refers to the Hong Kong SAR government, and if it owns or operates a ship and provides commercial service, that it will be bound by this clause. Another question, Chairman. I agree with your observation. If we take a look at the Chinese text, 3.2D, it says ship operated owned by a government in Chinese, and now I take it to mean that a government of any place, any country. Right. if we compare this with the English version, with the Article A, it's things are clear. But I share Chairman's observation. In Chinese, there is ambiguity as to whether the word 政府 in Chinese refers to a government or the SAR government. So I wonder if in Chinese you should put some qualifiers in front of the term to mean other governments or that government. Let's give Mr. Luk the floor.
Thank you, Chair. We adopt the practice that in English, because there are articles, and we would add the articles. In Chinese, there are no articles. We would not add the articles. As it says in 2D, it only says government in Chinese, while without an article, it's very clear it is not the Hong Kong SAR government. I think the current drafting is appropriate. Thank you. All right. Members, should we proceed? Okay, please proceed. Thank you. We're now at Part 2, Regulations. These are powers for the Secretary for Transport and Logistics to make regulations. We are to exercise a number of duties to ensure the implementation of the Convention. In Clause 4, the Secretary for Transport and Logistics is empowered to make regulations. In future, we may have other legislation or articles relating to ship recycling. So we will have a broader scope so that the Secretary for Transport and Logistics may make regulations to provide for the safe and environmentally sound recycling of ships, and the specifics are found in subclause 2. We may refer to international agreements and international instruments because we did say that we might refer to these convention provisions in international agreements and international instruments to avoid having to make amendments constantly. Therefore, we, in subclause 3 and subclause 5, we adopt a direct reference approach with international agreements and international instruments. Whenever there are changes, there's no need to amend legislation, and they will automatically come into effect. There are also various powers, say for inspections. In subclause 4, we have provided for the fact that there may be guidelines promulgated and referred to. All right, please proceed. Clause 5, regulations under Section 4, general powers and the relevant conditions. And these will be found in the regulations and subsidiary legislation. The regulations may confer on the Director any power that may be exercised by an administration or a competent authority under the Convention to recognize any organization to perform the functions relating to ships and ship recycling facilities, and to request the government of a convention country to perform any act that may be performed by the Director, as well as to provide for matters relating to the approval or authorization of a ship recycling facility, etc. For deficiency and a related appeal mechanism, they can be found in E and F. There are to G, H, and I. We also have in subclause 2 the regulations may amend schedule to Chapter 442 to make any decision made under this ordinance subject to appeal under that ordinance. Excuse me, I have a question. When we're talking about an organization, it can be a lot of things. It may be a society. In English, they use the word organization, right? In Clause 5, you have different names. You have organizations, authorities, and there are actually another place that said organization as well, but their Chinese versions are different. So with the different shipping functions, with the use of organization, should you change it to another term that says, for example, authorized professional organizations to make things clearer? Thank you, Deputy Secretary. Perhaps I'll try to explain what 1B does, and then I will let the Marine Department colleagues supplement my answers. Thank you. For 51B, it is about the director is empowered to recognize any organization to perform the functions relating to ships and ship recycling facilities. That means if the organizations do not have the relevant expertise, they will not get recognized in the first place. There is therefore no need for us to add the word professional before organizations because they will only be recognized if they are qualified to perform the relevant functions. Marine Department, anything to add? Thank you. For recognized organizations, well, basically, when we say here for any organization, in general, it would just be classification societies in operation. And they are recognized organizations. In marine legislation, we actually use the same Chinese translation for all of these recognized organizations. Well, would you consider it more appropriate if it said professional organizations? Because I think with any organization, the scope may be too broad. Chair, let me put it this way. For the word organization or the Chinese word 组织, it is already quite a broad term. As the Deputy Secretary said, the functions would be quite specific and some international standards have to be met. If the organizations do not have the relevant expertise in the first place, they will not be recognized by the Marine Department. Well, I think that is exactly what you mean by a professional organization. I think it is probably more appropriate for you to add the word professional here. Let me say this, for 51B, it is about an organization being recognized, need to perform certain functions, and the emphasis is on the functions. The functions must be related to ships and ship recycling facilities. If they cannot perform the relevant functions, even though it may be a professional organization, they will not be recognized. Mr. Frankie Yik, let me say something. For professional organizations, we have, for example, a ship recycling factory in Hong Kong. Would one have to obtain a license from the Marine Department? With the passage of the bill, they need to have their ship recycling facilities recognized before they can conduct ship recycling activities under the convention. Alright, I believe that means you would incorporate the relevant requirement by this bill. Yes. Alright, if there are no other questions, please proceed. Thank you. We're now at Clause 6, Part 3. Have you gone through C2155? No, not yet. Excuse me. C2155. Well, are you done with 5.1? Yes, and 5.3 is about the definitions that will be used in this section. Chair, I have a question about 5.1G on the fines. When you drafted this provision, why did you say specifically and a fine not exceeding $500,000 and imprisonment not exceeding 3 years? I have seen in other legislation it would be simpler. They would have a specific amount and a specific prison term. Why did you say not exceeding here specifically? Mr. Look, the speaker's microphone is not on. The speaker's microphone is not on. Hello? Hello? On the member's question, the G is not actually providing for the penalties themselves. It empowers the director to provide for penalties. So we have only the upper limits here because this is an empowering provision. I understand now. Basically, the director, when they promulgate the relevant regulations, they can provide for penalties such as fines of, say, $300,000 or $500,000, and in the regulation they would have a specific amount. Here it only spells out the upper limits. Correct. Thank you. Mr. Chen, please proceed. Thank you. We're now at Part 3 relating to inspection. Clause 6, authorized officers. The director may authorize any public officer to be an authorized officer. An authorized officer may exercise the powers or perform the duties that are conferred or imposed on the director under this ordinance. Such powers would include inspection at the facilities, entering the relevant premises, etc. The authorized officers, excuse me, Mr. Chen. Mr. Chen. You were talking about Clause 6, right, in Part 3? Where are you now? Are you in Clause 8 now? Oh no, I'm still on Clause 6 on authorized officers. Authorized officers are often public officers appointed to exercise certain functions, and in another relevant ordinance, it is also the same. We have adopted the same approach. Any questions from members? If not, please proceed. Thank you. Clause 7, delegation by director. The director may delegate to any other public officer the exercise or performance on the director's behalf of any of the functions. This is also a commonly used practice, and in Chapter 369, 133A, we also have a similar approach. Thank you. Please proceed. Clause 8, power to board ships by authorized officers. For ship owners and ship personnel, they must allow the relevant inspection if the authorized officer has already bought a ship that applies at a ship to which this ordinance applies at any reasonable time, and they may bring with them equipment or materials. No application of warrants in advance is required. This is in line with current practice by the Marine Department. Thank you. If there are no questions from members, please proceed. Thank you. Clauses 9 to 11 relate to power to enter premises used as ship recycling facilities. First, on Clause 9. At times other than in emergencies, for the power to enter premises used as ship recycling facilities, an authorized officer may enter the relevant premises to make sure the facilities are in compliance with the convention, and the authorized officers may enter the premises if the premises are non-domestic premises or they believe the relevant premises are being used as ship recycling facilities to which this ordinance applies. If for some reason an authorization of the director is given, then the authorized officer must show the relevant authorization. There are two members who would like to ask questions. Mr. Chen Siu-hong.
Thank you, Chair. I have questions on clauses 9, 10, 11. According to the administration, say for clause 9, power to enter premises used as SRF other than in emergencies. An authorized officer who has reasonable grounds to believe that any non-domestic premises are being used as an SRF, then the officer may enter the premises without a warrant. I wonder if too much power is being given to the authorized officer, because with this power, the authorized officer can board the ship when he has reasonable grounds to suspect that it is an SRF. Well, in urgent circumstances, I understand that no warrant should be required. Otherwise, the evidence will be eliminated. But for times other than in emergencies, why should we allow authorized officers to exercise their own judgment and exercise the power to enter premises? Yes, thank you. Now for clause 9, it refers to inspection other than in emergencies. So you can imagine authorized officers may wish to inspect a number of premises, A, B, C, for example, and that the owner or operator would open the door very peacefully and welcome the officers in, and this is what we regard as a non-emergency situation. For clause 10, because we suspect that an offense might have taken place and we need to enter the premises at once in order to collect evidence. For clause 11, since there is reasonable grounds to suspect that it's a domestic premises used as an SRF, a court's warrant will be required before entering. So it comes in 3 tiers. Chairman, in other words, as I understand in clause 9, when the authorized officer has reason to ask for entry of the non-domestic premises other than in emergencies, then the owner or operator may very peacefully open the door and let you in. But say if the owner or operator is non-cooperative, you can then rely on clause 10 because it is an emergency. But in the end, even in a case of emergency, the authorized officer may be refused entry. So the officer will then resort to clause 11. That means they will need to apply for a magistrate's warrant to have lawful entry. Any other questions? No? Mr. Benson, look. Chairman, some questions on clauses 9, 10, 11. I have a question for the administration. According to my observation, for entering the premises without a warrant, one criterion is that it should be a non-domestic premises. In clause 11, however, if a warrant is required, it refers to both non-domestic and domestic premises. So does it mean that for officers without a warrant, under the current legislation, no entry may be allowed into a domestic premises for investigation? Yes, thank you, Chairman. Thank you, Mr. Lok, for his questions. His observation is correct, because no ship recycling activity should take place in domestic premises. So if we're talking about a regular inspection, then the officer should not be gaining entry into domestic premises for this purpose of inspection. Since private property is involved when it comes to domestic premises, a high degree of protection should be given. The legal advisor has a question. Is it coming through? Thank you, Chairman. We asked the administration about the powers under Clause 12. According to the administration's reply, the authorized officers will strictly abide by the provision as well as the IMO's guidelines. Can you further clarify in terms of enforcement, how should the provision be invoked, or how should the guidelines be followed? I'll give the floor to Mr. Shi, Director of Marine. Well, as explained earlier, the IMO has already published 6 sets of guidelines. The guidelines set out in great detail matters relating to ship surveying, inspection, the SRFs, etc. So the authorized officers carrying out inspection do so in line with the guidelines or the provisions. But then the IMO may update their guidelines. A follow-up question, Mr. Chen? Clauses 9, 10, 11. I have a further question. After entering non-domestic premises on reasonable grounds, if the authorized officers then observe a violation, the officers will then need to seize and detain items as evidence in court proceedings. I don't see anything in this provision that empowers the authorized officers to do so. Let's say after observing that a violation has taken place, the officers will then need to apply for a court warrant before revisiting the premises. And by then, the evidence will have been eliminated. Can you tell me how the authorized officers will be empowered to do that? Any reply? The details can be found in Clause 12. Mr. Lok? Chairman, if I may, I'd like to walk members through Clause 12(1)(d). Powers to inspect, examine ships and premises, and inspect, seize, and remove from the ship or premises any article or substance where the officer has reasonable grounds to suspect that an offence has been committed. So that's one of the powers under Clause 2 given to the authorized officers. Right, please continue, Mr. Chen. Are we on Clause 12 now? Let's go straight to Clause 12. Right, we've completed Clauses 9 to 11. Clause 12 sets out the powers of the authorized officers after boarding a ship under Section 10 or entering premises under Sections 9 to 11. Authorized officers are required to inspect and examine the ship and premises to check for compliance. Well, this is drawn up on the basis of Cap 413 of P. That sets out the powers of the government ship inspector in conducting inspection. We add another subclause under Clause 12 about the authorized officers' powers in inspecting premises used as SRFs to ensure that this can be implemented. For Clause 12.3, it sets out the penalty, which is a fine at level 6, and also subclause 4. There is a difference in terms of the power to be exercised here and under subsections 1b, h2, or 3, because for these provisions, the person in question will need to follow certain requirements. It may be requested to provide information, answer questions, sign declarations, etc. Because the the information provided may constitute evidence in criminal proceedings, this person has a right against self-incrimination, and we put in place this defense of reasonable excuse to protect the defendant's rights. This is in line with Cap 413Q, Section 4, that is Merchant Shipping Control of Ballast Water and Sediments Regulation. Clause 12, any questions? Right, on to Clause 13 then. Clauses 13 and 14 are similar provisions. One relates to ships, the other relates to premises used as ship recycling facilities. If the exercise of a power in relation to any ship under 12.1 reveals a deficiency, the director may give a direction to the owner or master of the ship requiring the owner of the master to cause the ship not to proceed to sea until the deficiency is rectified. From a commercial operations perspective, stopping the ship to proceed to sea will cause significant pecuniary losses. According to experience, masters or owners will usually rectify the deficiency once receiving this direction, or they could seek assistance from classification societies. Now, on contravention, the owner or master may be subject to prosecution, and for conviction on indictment, he may be penalized at level 6, or summary conviction to a fine at level 3. And if this person is not an owner or master of the ship, then the person breaching the law may still be liable. Again, we've made reference to the same levels of penalty of Cap 413Q, that is Merchant Shipping Control of Ballast Water and Sediments Regulation. It sets out the liability of the owner, a master, in following the director's direction, and the penalties. Mr. Chan Siu-hong. Clauses 13 and 14 refers to a new term called deficiency. But we haven't examined the definition of deficiency. Clause 13.1 refers to entry into the premises, investigation. Will the offender be told what the deficiency of it is about? For example, does the deficiency refer to the lack of an inventory of hazardous materials relating to ship recycling, or has it to do with pollution? The deficiency may come with different magnitudes. So how do we make sure that there is no deficiency, or that this deficiency is manageable, it can be rectified, in other words? Because we do not see a definition for the term deficiency here. If it's spelled out in another provision, please please provide us the reference. Yes. Thank you, Mr. Chan, for the questions. I will ask the Marine Department to take these questions. They can tell you about their enforcement experience under a similar mechanism. They can tell you more about their enforcement approach. Right, please walk us through the definition of the term deficiency in these two clauses. When it comes to SRFs, deficiency refers to anything that is against the Hong Kong Convention. In our regulation, we will set out in detail the requirements in the Hong Kong Convention. Now, as for our day-to-day enforcement, I can give you some examples of deficiencies. For example, this ship may not come with a certificate, or that this certificate is not up to date. The certificate is not, does not tally with the details of the ship. The design of the equipment of the ship may have changed. Some of the equipment may have been removed, but the new equipment has not gone through examination and is not stipulated in the certificate. For SRFs, for example, the ship recycling or scrapping may take place without a license or permit. The owner or master is required to comply with the requirements in the Hong Kong Convention, or else it will be a deficiency. And we also require a ship recycling plan to be submitted for each ship subject to ship recycling. If the plan doesn't meet the requirement, again, it's a deficiency.
Chair, from what I heard, that means in regulations you would have more on this. But in principal ordinance, you need to make sure there is greater detail. Why not spell out what the particular contraventions are that would make you give out penalties? The other regulations would be subject to negative fitting. We would be able to see what contraventions there may be, but here you only have the word deficiency. There is no definition. We only rely on what was said by the director just now to know what the potential deficiencies may be. I think it is not ideal. Can't we just refer to the convention for the relevant deficiencies as well? Mr. Look. Well, to address the members' questions for 51E, we actually said already for clause 13.1 and 14.1, the director may, in the regulations, provide for a deficiency referred to in the relevant sections. This is already a starting point for sections 13.1 and 14.1. The deficiency will be provided for in regulations. I understand where you came from. My question was, since you're already going to provide such in regulations, why not provide them here instead of only referring to the term deficiency? I suppose in the regulations you will not define what the deficiencies are specifically. You would just say you can't do certain things in regulations 3, 4, 5, 6, whatever. The problem is we do not see the regulations today. We are asking a series of questions, and these may be obvious questions to you, but without the details in regulations, we rely on our imagination what potential challenges there may be. What will you say in the regulations, roughly, then? Deputy Secretary, can you tell the member more about the regulations? I understand where the member came from, but we need an empower ordinance in the first place to implement the regulations. We are already drafting the regulations. If you think that we should define deficiency, we can definitely do that in the regulations. Chair, I think this is not an unreasonable request. When we scrutinize other bills, I have observed for the details about implementation, they have yet to be promulgated. But for the scrutiny of the principal ordinance, the framework, there were cases in which the draft regulations, without the details, of course, maybe just a skeleton would be provided for members' reference, and they would say specifically that's just for reference. Can the administration do that? Because that will definitely help us have a better picture. I think the Deputy Secretary already gave a reply. Are you satisfied with the reply? Chair, I think we'll try to do something after the meeting. We are drafting the regulations in tandem with the scrutiny of this ordinance. It would depend on the drafting progress of the regulations, whether we can even provide a skeleton. But I think we will at least try to provide a skeleton. And with the regulations, I am more than willing, when the draft regulations are ready, to arrange a meeting with members to explain the details of the regulations outside the meeting. I would agree. I observed the Deputy Secretary for various policy matters and legislative matters. She has explained things very clearly, and she has always managed to communicate with members. I'm just saying it would be ideal if we could have at least a skeleton. If it is not possible to provide a skeleton, I would understand. We just want to make sure the ordinance would be effective, but then it wouldn't be too tight that would cause inadvertent breaches of the law. I think the Deputy Secretary understands where you came from, and if possible, I guess she would try to, as soon as possible, arrange for a meeting with members, or at least provide a written response. All right, Mr. Chan, please proceed. Thank you. We're now at clause 14. It is very similar to clause 13 as said earlier. This is deficiency revealed in relation to premises used as ship recycling facilities. The director may give a direction to the operator of the ship recycling facility requiring the operator to cause the facility not to operate ship recycling until the deficiency is rectified. For contraventions like clause 13, we have referred to chapter 413Q, the penalties in the ordinance. It will be a fine at level 6. On summary conviction, it will be a fine at level 3. So these are the penalties in merchant shipping control of ballast water and sediments regulation, chapter 413Q. Thank you. If there are no questions from members, please move on to clause 15. Thank you. Clause 15. We have referred to again a similar piece of legislation. For any contraventions, a fine at level 6. A person must not willfully obstruct an authorized officer in entering the relevant premises or inspecting the relevant premises. In 1A in particular, it would provide for making sure there is protection for the authorized officer so that they will not be willfully obstructed. In B, it says in particular that the person should not provide information that is false or recklessly provide information that is false. This is again to prevent officers from being misled. Mr. Chen Su-hong, thank you. We have in Clause 15 about a person not providing information that is false or making a statement or signing a declaration that the person knows is false. Contraventions to this would incur a fine at level 6. In other pieces of legislation, the penalties appear to be heavier, say hundreds of thousands in fine or even an imprisonment term. So here the fine is just level 6. I think the offenses are similar in other pieces of legislation. It is also about providing information that is false or giving a false statement. So why is there a disparity in the penalties? Thank you, Chair. Thank you, Mr. Chen, for your comments. I think with enforcement, it's not just about prosecuting someone on making a false statement or providing false information. It would be a whole package. They would have contravened other articles of the convention that would constitute offenses. I believe it would be a comprehensive investigation. We would not have the relevant individuals only charged for signing false declarations, but of course we would need to gauge the evidence in the case in order to see what to prosecute. All right, we're close to 6:30. I will extend the meeting by 15 minutes. We're now getting to Clause 16. Please proceed. Thank you, Chair. We are explaining what reasonable excuse is. We have at different clauses talked about a reasonable excuse, and in Clause 14 it is about without reasonable excuse the operator commits an offense if they contravene the relevant requirements, and authorized officers may inspect premises if necessary. And in accordance 12(1)(h)(2) and 3, the authorized officers may require the relevant persons to provide answers and or sign declarations of the truth of the person's answers. So for the relevant provisions, we are providing a reasonable excuse defense to prevent people from self-incriminating. For 13.3 and 14.3, they are about a deficiency revealed in relation to ships or premises used as ship recycling facilities, the operators or the owners and masters of the ship refusing to comply with directions of the Director of Marine. We have provided for a reasonable excuse defense for them to be acquitted if they can establish the relevant defense. All right, any questions from members? If not, please proceed. Thank you. We're now at Part 4, exemption. This part allows the director to grant exemptions for ships or classes or descriptions of ships or ship recycling facilities. The director may also alter or cancel an exemption granted. This allows the director to have regard to the circumstances, grant exemptions if necessary. I have some comments about this clause. if the director grants without any conditions exemptions, would that give the director too much power? If we say the director may impose conditions or must impose conditions in exemptions instead of allowing the director to exempt from requirements of the ordinance, the ships and ship recycling facilities, absolutely. Deputy Secretary, I would say this, even though the director may exempt the relevant parties from requirements of the ordinance, absolutely, it would be the case that it would only be limited to ships, classes, or description of ships or ship recycling facilities. We want to maintain the current drafting because we want to have flexibility because we don't know what will happen in future, what technologies there are, for example. But we think members can rest assured because the policy intent is to implement the Hong Kong Convention. Whether conditions are imposed or not, there will be the premise of implementing the Hong Kong Convention.
Yes, so in fact, it is subject to some conditions, but on the face of it, it seems that the director has been given excessive powers. Indeed, Hong Kong, as a shipping register or as a party to maritime conventions, is widely recognized by the international community. We have over the years been able to implement international conventions in a precise manner, and we are not going to be arbitrary because we definitely will not do anything that may jeopardize Hong Kong's reputation. Mr. Chan Sil-hong. Thank you, Chair. Clause 17, subclauses 1 and 3. Can you tell me more about the implementation? Now, like the administration said, even if it says that no condition is required, here, in fact, the exemptions are subject to certain conditions. The ultimate goal is to comply with the Hong Kong Conventions. Now, clause 3, an exemption granted under subsection 1 is subject to conditions. And then the exemption is not to have effect unless the conditions are complied with. So it's not as suggested in subclause 1. It actually supplements subclause 1 that in fact you are required to comply with conditions. Is that right, Mr. Lok? Thank you, Chair. This is indeed true. So Mr. Chan's comment is correct. Right, so Mr. Chan's understanding is correct. If that is the case, I have no further comments. Please go on. Part 5. Part 5, miscellaneous. Clause 18 provides access to convention by the public. The director must keep a copy of the English and Chinese text of the convention at the office of the Marine Department. The public should be allowed to inspect the text during normal business hours free of charge. Should there be any revision or update of the text of the convention, the relevant notices should be published on the website for reference by the industry. Mr. Benson, look. Thank you, Chair. My question is this. Technology is so advanced today. Why do we still require hard copies to be provided? Is it due to the convention that we must keep a physical copy at the office. Has any member of the public ever visited the office to inspect the physical copy of the convention? Yes. I thank Mr. Look for his comment. The IMO owns the copyright of this convention. The Marine Department is unable to publish copies of the convention on the website for public access, and that is why the full text in Chinese and English of the convention is placed at the office of the director for public access. So in other words, no online access. One can only inspect physical copies. Is that right? We're not keeping with the times. Because the Marine Department does not own the copyright of the convention, the Marine Department cannot act unilaterally on behalf of the convention by publishing the convention online. So this is in fact, a practical compromise. But can you talk to the IMO? This may be a legacy issue. The requirements were laid down years ago. Mr. Chang? Thank you, member, for the comment. The IMO has this mechanism. You can apply online for retrieval of part of the convention. You need to state the party you're representing and the reasons why you need to have this access. They are very strict in keeping this copy. So in other words, you do allow online access through application. Right, Chairman, in other words, for other contracting parties, they also adopt a similar approach. Is that right? Mr. Chang? We started adopting this practice about 20 years ago because of the direct reference approach in our legislation. That means we're not directly copying all the provisions in the convention. Since part of the convention is not directly accessible by members of the public for the sake of compliance, we put in place this mechanism. We allow physical inspection of the physical copies of the convention so that the convention can be read together with the local legislation. Mr. Chan Sil-hong. The administration already answered my question. Any stakeholder or member of the public who wishes to fulfill their responsibility as per the convention and the local legislation can apply with the IMO to retrieve all the relevant parts of the convention for inspection. That's the practice over the years. Chairman, I still have another short question about granting of exemptions by the director without condition in Clause 17. Let's see if my understanding is correct. I understand Chairman is concerned about excessive powers being given to the director. Now, the director may be able to grant exemptions unconditionally, but an appeal mechanism is also available. For example, the avenue of a judicial review. So I suppose the director will be wearing some sort of a straitjacket, right? Yes, I did ask a question on review mechanism. Judicial review is allowed. That's reassuring. Anything else? We've gone through all 18 clauses. We've completed the clause-by-clause scrutiny of the Chinese text. Legal advisor, any comment on the English text? Thank you, Chair. About the legal and drafting issues of the bill, we wrote to the administration. The administration already provided a written response. Apart from that, we have not identified other drafting issues nor or inconsistencies between both versions. Members, is there a need to hold a public hearing? Should we invite the public to submit written views on the bill? Written views only, right? So this invitation will be published on the website of the Legislative Council. We will invite the administration to give a consolidated response if views are received. Does any member wish to move amendment to the bill? No. The Secretariat will discuss with the administration when the second reading of the bill should be resumed. Members will be informed of the arrangements and will be submitting a report to the House Committee. Anything else from the Deputy Secretary? No. I thank members, the Bills Committee and the Secretariat for your work. Right. If there's nothing under AOB, thank you for attending today's meeting.